Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us today, November 23rd, 6 p.m. Pacific time, not specific time, Pacific time. We're here right before Thanksgiving. A lot of people internationally are celebrating along with the United States on this day. Food and with family and all that kind of stuff. We'll see how many people could come on the show. We already have some questions and a small group lined up. But we're here talking about U.S. immigration for educational purposes only, general ideas about the process. We can take from there. A note for those watching live, I do give out free video consultations, 15-minute video consultations for watchers. All you need to do is like, subscribe, and write consultation in the in the comment section. And my wonderful assistant Katrina will name a winner every 10 minutes. So we'll have 3 of these, and then we could take it from there. So just let you know that, and start throwing your questions out for those watching live. And also, if you're interested in a family-based marriage kind of green card, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. It's a really good guide that really guides you in the process of getting a green card. Even if you're kind of getting other kind of green cards, there's a lot of overlap, so you'll learn a lot about it. Now, I do want to mention we have another show called the Immigration Talk Show, where my associate Anya Sergieva and I talk about different topics in immigration. It's weekly. It's just really hot topics, and we go into a lot more detail. So definitely check that out. It's on the YouTube page at JQK Law. Links are everywhere else, wherever social media for JQK Law is. You can catch it there. But JK Law, the website, the YouTube page is probably the best. Definitely subscribe to the channel, like it, to get more attention, let more people know about the information we have. And with that, let's get it started. All right, so we got a couple questions. First off, Hannah asked, after the asylum interview, how long will it take to get a decision? What's the process if you get accepted? Well, it varies. Usually it doesn't take much time after the interview, but sometimes it takes many months, 6-7 months. So there's no fixed answer to when you have an asylum interview, how long it'll take afterwards to get a decision. Most of the time it's not too long, but sometimes it could be long and still be an approval. And then once it's approved, well, you have asylum status. About a year after that, you can file for a lawful permanent residency, a green card. And then, 4 years after that, potentially, you could file for U.S. citizenship. There's a lot of different factors that go into consideration for those, but all of it's possible. Hopefully your interview goes well, you get the asylum status, and you're able to file green card fast after that. But that's about it, Hannah. Thank you so much for tuning in and your question. Sam Nas, hi, Mr. John, happy Thanksgiving. Same to you. What documents do you need to bring for an N400 interview-based marriage as standard case, no criminal history? What document of U.S. citizen to bring, original or copies? Well, you need to bring originals essentially. So this is general information I'm giving. Your case may be different, Sam, so I gotta say that beforehand. But you definitely want to bring your marriage certificate, original. Your copy probably should have been submitted with the application. If you've been divorced before, your spouse has been divorced before, original divorce certificates, copies should have been given in the initial application. If you had any military history, having completion of that or whatever it was, information there. Again, this is general information, not case-specific guidance, so you need to contact the immigration attorney on your own. But along with that, typically not too strict, but evidence that you've been residing together if you're filing for citizenship based on a 3-year status based on marriage. 3 years of tax returns, lease agreements covering where you live together. I typically haven't been seeing them too strict on this or going too much into it. A proof you've been living together. Now, has your I-751 been approved yet or not? And you may have not needed an I-751. So if you had a 2-year green card, did you apply for a 10-year green card, and had that 10-year green card been approved yet? That's some factor I'll take into consideration or bring evidence for your relationship. But typically, joint tax returns and lease agreement is all you need to prove that you've been residing together for the 3-year citizenship as opposed to 5 years. Proof of your wife's status, naturalization certificate or passport potentially. Usually they don't need all this stuff, but if you want to be safe, the more you bring, the better. Copies should have been mailed. Originals to the interview. If you had mailed copies in, then bring a copy of any original document you bring with you to save the officer the hassle of having to make copies of it. Some officers will happily do it. Some of them will say, I'm just not going to do it, and I'll RFE it. So it just depends on the personality that you get. But good luck, Sam, in your interview. So Sam, now sorry, divorce copy of my spouse from our previous marriage, not for me. Yeah, all divorce certificates you should have certified original copies. They want to make sure all the divorces in a citizenship case, in general, when you're going to file for a case and you're married, for example, based on marriage, or you're going to do marriage just in general, in the US, you're only allowed to have one spouse at a time. And so you got to make sure that the previous marriages for you or your spouse have ended before a new marriage comes into place. And sometimes I've seen cases where someone thought they got a divorce, but it wasn't properly done, and then they got married, and all of a sudden they're married to two people at once because the previous divorce wasn't finalized and they got a second marriage. And then at citizenship, they realize this, and then they lose their green card and potentially deportation. So they want to check to make sure all the divorce timelines and marriage timelines are correct, so you need to bring them all to be safe. You ask, I submitted my I-130 in February. I just submitted I-45 yesterday. Wife only has a 10-year green card and just applied for citizenship. When she becomes a citizen, will the case turn to a citizen kind of case? Not automatically. They don't talk to each other. So you have to notify USCIS if you have a marriage green card based on a green card holding spouse, and now they're a U.S. citizen. You have to notify USCIS that the spouse is a citizen now. It may or may not make a difference. I've seen it cause a difference for cases process faster, and I've seen cases where it just stayed the same. So that's about it. It's not much going on. When she does become a citizen, yeah, notify them, why not? But then it's up to them if they want to make it faster or not. 29 Super C, any general advice for EB3 interview attorney Khosravi? Thank you. You're welcome. So I don't typically deal with EB3 or EB2 cases, but it's very similar when you're doing consular processing for an immigrant visa case. Primarily, fill out the DS-260 form properly so your information is correct, there's no inconsistencies, and have your civil documents prepared with translations if needed. So birth certificate, marriage certificates, divorce certificates, military records, any unique kind of things that might be needed based on your background. And then when you go to the interview, be prepared to be able to talk about what your skill is that you're bringing the company is, so they don't think this is some sort of fake job and you don't know what the job requires and stuff. But I think in your case, you have experience working with this company in the past, so there's less of a doubt about that. But for general kind of people who are watching this, you don't want to go to your interview, and obviously if it's, I'm saying this to a person that has a valid, honest case, not a person who's scamming, but you don't want to go and not be able to answer questions about who the company is that's hiring you, what your work is, what you expect it to entail, how much money you expect to make. You got to know these details because these are details that should have been negotiated with a company with regards to your contract, now what you're making. But also, if you're going to work for somebody, you want to know what their name is, what their address is, or maybe memorizing the address not as important, but know where they are and what they do, what their history is, so you can explain to them and be able to show that. So that's something to keep in mind on these kind of cases. Paranoid Android, another regular ask, as an O1 with a U.S. agent for multiple employers, can I be paid by a foreign non-U.S. company with U.S. address, only U.S.-based companies? I'm not an O1 attorney. If it's in your itinerary, you could do whatever, frankly. But I'm not an O1 specialist. This is extraordinary ability visa for people coming to work temporarily in like an extraordinary visa kind of case. But I would say, talk with an O1 attorney in private about planning this out. This is too case specific. There's some guidance we give, but it's not appropriate in a public forum to plan this out. So I would just say best to talk with an attorney. I wouldn't be a resource for that myself, but definitely talk with an attorney in private. So here I ask, hi sir, we expedited my brother's case who was in Afghanistan, got approved, sent to embassy, so will that take 12 years? Yeah, the I-130 being expedited doesn't make a difference. It's the visa bulletin, so they need to wait for their case to be current. So I expedite I-130, it depends on what it is, if it's a marriage case or your brother's a minor and a parent that's a U.S. citizen file for them or something like that, yeah. But I don't know exactly who submitted the petition, but generally expediting the I-130 that doesn't make a difference. They still need to wait at the embassy, unfortunately. Hannah asks, do you have any idea why the EAD is taking so long to renew? USCIS is having major issues with renewing, even giving the initial EAD or work permit, as well as renewing it. There's lawsuits on it which have sped it up, so I don't know what category EAD you're doing, but for example, the H4, the L2, the E-Visa, they're pretty much been sped up to, or they have automatic extension. So I'm not sure if that's the category you're going under. But for other ones, yeah, you could try filing a lawsuit if it's urgent. Lawsuit costs money too, so I'm not sure if that's a good match for you. But it's a big issue that USCIS is having, massive delays for EADs. And as I said, there's a lot of lawsuits going on about this, but it's a very harsh thing that's really hurting a lot of families. Enos asked, I recently filed for adjustment of status through marriage to a U.S. citizen. I also got a job offer and they just applied for a no-cap H-1B for me. Do these two cases affect one another in any way? Not really. Probably it's no cap H-1B, so it's not a bad idea, but just got to make sure that information is consistent in there. But they don't normally touch each other. I can't say for sure because I don't know the details of your case or your background, so I can't give you like a for sure kind of thing. But not really. They usually don't. And a lot of times the H-1B is just not necessary because if you have a marriage adjustment through U.S. citizen, depending on what city you're in, you're probably going to get your visa, and the H-1B was overkill and wasting money, but it's not a bad thing. Why not have it? Mindy asks, should I send the I-693 with the I-485 at the same time? Is there a disadvantage of sending it separately later? So I-693 is the medical checkup that comes with a green card application in the United States. It is possible to submit it with the green card application. It just depends on if you want to do that or not. The I-693, if properly submitted, is valid for 2 years. If your case is going to take longer than 2 years to be approved, and sometimes it does take that long, then it's going to get expired and you'll have to do a new one. So I typically tell clients, it depends on what kind of case you have. And Mindy, I can't recall what we talked a little bit at the first of the show, but I can't recall what kind of case you have. At least go EB-1A. So I'm not sure when your EB-1A green card is going to be approved. So I typically wait for USCIS. I submit the I-485 and wait for them to send a request for the medical, and then I mail it to them. But you might want to do it differently. It's up to you how you want to do it. There's different tactics. Some lawyers submit it with the I-485, some don't. I just do it on a case-by-case basis. I don't know your country of birth, so I don't know where your place is in the visa bulletin. I think they're all current right now, visa bulletin for EB-1A. But I just need to know more background and to be able to kind of judge this. And it's random, so it's going to be at the end of the day up to you if you want to do the medical checkup and submit it with the I-485. But what is important if you're going to do that is the doctor's signature on the I-693 must be within 2 months of the filing date of the form I-485. And that sometimes is problematic. So let's say you go to the doctor and a month later you submit the I-485, it goes to USCIS, there's some sort of error with the case, and they return it to you and you have to resubmit it. But by the time you realize there was an error and they return it to you, 2 months have gone and that medical is expired and you have to do a new one. And this kind of stuff pops up. So that's a factor to take into consideration. But looking at it, yeah, every country is current on a visa bulletin for EB-1A, so it shouldn't take that long, but who knows? Who knows with USCIS how long cases are going to take. Now I'm going to ask, how long does the time for an I-130 petition for parents? So you have to be a U.S. citizen to do an I-130 petition for parents. And once you submit it, average takes between 6 to 10 months for them to believe you're really a parent. They're really a parent. I have one case that's taken 1.5 years, but their documents were confusing. But average 6 to 10 months. But that's the I-130 petition. If they're overseas, then you have to deal with consular processing, and the timelines on that are unknown right now. It's just embassies are very slow to process, so it's not clear when the case will be over if you're going to do consular processing. But for the I-130, 6 to 10 month average. Mike asks, okay, Ayo asks, I'm an OPT and also submitted I-765 for my I-485. Any advice on it? Not particularly. Just note that the I-765, the employment authorization document or work permit request for I-485, the code is C9, so hopefully you put the code right, is different from the code used for OPT. But other than that, that's that. I mean, if you want to maintain your F1, continue working on whatever the OPT work was. If you start using the employment authorization document from the I-485 and work at a different job that's not connected to what you told them on CVIS for your F1 student visa, potentially your F1 visa gets invalidated, probably won't make a difference. The only difference it will make is if you end up getting divorced from your spouse before your case is approved or you get separated or something like that. But barring that, it doesn't make much of a difference. Nicole follows up, my husband was just approved citizenship. Once he swears in, can he apply for his dad to come and visit? So you don't need to be a visitor visa doesn't need someone to apply for. You apply for yourself. So your husband's dad, if he wants to visit the United States, could do so right now or later. They apply for a visa. Whether or not the tourist visa is approved is up to the embassy, but you don't need your husband to be a citizen to apply for that. It has no correlation per se. If anything, it makes it less likely they're going to approve the visa because they know once your dad comes to the United States as a tourist visa holder, he can apply for a green card in the United States and kind of bypass the embassy process. But if what you mean is, can your husband apply for your dad to come and live here and get a green card? Yeah, once a citizen, typically in these cases, if the parent wants to reside in the United States, we immediately have it planned to file the I-130 on the day the oath ceremony happens and you get the naturalization certificate, immediately file for the I-130 petition for the parents so they can come and live here. But if they're just trying to come and visit, then they should just go and apply for a tourist visa. There's no point in waiting for citizenship. Do you continue different So I think what you're saying is there's a green card holder who filed for their unmarried child, but that unmarried child got married. What happens to that petition? Unfortunately, and we talked about this in episode 5 of the Immigration Talks coming out in a few days with my colleague Anya Sagiva, that new talk show we have. No, unfortunately, the case gets disappeared. It gets voided because they were married. If that's what your question is asking, green card holder filing for adult unmarried child. If that unmarried child gets married while the petitioner is still a green card holder, the case gets voided. So sorry, hope that's not the case, and that's done. With that said, thank you for watching. Happy Thanksgiving. Have a great week, and we'll see you all in December. God bless. Be safe. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.